Chris Sample for the plaintiff. May I proceed?
You may.
Good afternoon. Good afternoon. Please introduce yourself to the members of the jury. Spell the last name for the record.
My name is Dr. Campbell Solo, S-O-L-O.
Dr. Solo, what do you do for a living?
Well, I began my career as a staff psychologist at Breckenridge County. From there, I became an adjunct professor of psychology at Midland State University. And now currently I run my own firm, Solo and Associates.
What education do you have?
I started my academic career at the University of Oregon, where I received my Bachelor of Arts in Psychology. From there, I obtained my medical degree from the University of Michigan. They call me Dr. Campbell Soup. From there, I did my general psychiatry residency at St. Mary's Hospital in Madison, Wisconsin, and went on to do my child and adolescent psychiatry residency at Breckenridge County.
Turning your attention to today's case, how are you involved?
Well, I was hired to examine two questions. And those two questions were whether Jesse Duran posed a special danger with regard to firearm, and if that danger manifested before August 18, 2010.
Before you work in today's case, did you have sufficient facts and data?
Yes, I had access to a number of affidavits, evidence, and reports.
Did you use reliable principles and methods?
Yes, I used standards that are widely accepted in my field of psychology.
And did you use those principles and methods reliably to the facts of today's case?
No other way to do my job.
Now, what did you find when you looked at these facts, when you looked at your facts and data?
Well, when coming to my conclusion, I answered both questions. Yes, Jesse Duran posed a special danger with regard to firearms, and yes, it manifested before August 18, 2010. Also, when coming to my conclusion and formatting and reviewing the materials, I've come across risk factors I found in Jesse, in which I referenced from a peer-reviewed study that identified various warning signs and risk factors that increase violence in children.
How many risk factors did you find with Jesse?
I found 3 risk factors in Jesse, but in this case, in any case, you only need 1 to be considered violent.
Now, I want to take these risk factors one step at a time. What's the first risk factor?
The first risk factor I found in Jesse was exposure to violence in media.
Objection, lack of foundation.
You wish to respond to the objection?
Your Honor, laid a foundation of this expert witness to testify to his conclusions in today's case. He told us that he relied on a variety of affidavits and expertise in his field, and therefore he can testify to this.
Response? Reply, you mean?
He did not explain how he used his methods in today's case, but merely stated that he used methods.
I'm going to overrule the objection. Doctor did testify that he had reviewed numerous documents and affidavits in preparation or as he did his analysis review. You may proceed.
Yes, Your Honor. Now, what was the first risk factor, Dr. Solo?
The first risk factor was exposure to violence in media.
Now, can you elaborate that for the members of the jury?
Yes, as I reviewed the materials, I learned that Jesse Duran was extensively exposed to violence in media, particularly violent video games. I also learned that Hayden Duran played and bought these video game, first-person shooter games for Jesse. First-person shooter games are the player or the controller is behind the eyes of the shooter. Studies have shown that children who view or play violent video games are more susceptible.
Objection, narrative.
Response?
Your Honor, I asked this witness to elaborate on the first risk factor, exposure to violent media. And that is what he's doing.
Reply?
He already stated that Jesse was exposed to violent media and does not need to go further into this explanation.
Your objection was narrative.
Yes.
I'm going to allow, I'm going to overrule the objection. I'm going to allow the testimony. You may proceed, counsel.
Can you continue with your answer, Dr. Solo?
Yes, well, studies have shown that children who view or play violent programming are more susceptible in imitating what they see versus children who don't view or play these types of programming.
I want to direct your attention now to the second risk factor. What is the second risk factor that you saw Jesse experiencing?
I learned previous aggressive behavior.
Can you tell the members of the jury what led you to believe that Jesse had this type of behavior?
Yes, I found quite a few pieces of evidence to support this claim, such as the notification of student discipline received from Jesse's school, or sent out from Jesse's school, as well as an email sent from Hayden Duran to a coworker or friend.
I want to take this disciplinary note in this email one step at a time. Would you recognize the student disciplinary note if I showed it to you today?
Yes, I would.
Permission to approach opposing counsel with.
Okay.
Permission to approach witness with same. Dr. Solo, what if I just handed you?
The notification of student discipline.
Does it appear to be a fair and accurate copy?
Yep.
Now, who was given, to your knowledge, who was given this disciplinary note?
This was sent out to Hayden Duran.
And how do you know
Objection,
this?
these facts are not in evidence.
Response?
Your Honor, I'm laying foundation before entering this piece of this exhibit into evidence. No, nothing has been referenced from this document specifically. And because of that, I'm allowed to ask this question.
Reply?
He is actually citing directly from the document who was given this document. As it says, the parent on file is Hayden Duran.
We do overrule the objection. I'm going to allow the testimony. I believe we've already heard testimony. This is amongst the documents that he reviewed. Therefore, I'll allow further elaboration. You may proceed, counsel.
How do you know that Hayden Duran received this disciplinary note?
It was signed Hayden Duran under the acknowledgement paragraph.
Your Honor, at this time, plaintiff moves into evidence, plaintiff's exhibit number 4.
Did we skip exhibit 3?
It's identified as number 4, Your Honor.
Exhibit 4. Any objections to exhibit 4?
No objections, Your Honor.
Permission to publish this document to the jury.
Exhibit 4 is admitted, may be shown to the jury.
Now, what did you learn about this disciplinary note without reading the entire document?
What I learned is that Jesse Duran was being suspended from school for violently attacking another student for the 3rd time, i.e. punching, kicking, and biting, as well as making comments like, "I hit you, you're dead, you need to fall down and die."
Permission to approach witness and retrieve evidence. Dr. Soli, you also spoke about an email from Hayden Duran. Would you recognize that email if I showed it to you today?
Yes, I would.
Permission to approach opposing counsel.
You may.
Permission to approach witness with the same.
Yes.
Dr. Solo, what have I just handed you?
The email sent from Hayden Duran.
Now, first off, how do you know that this email was written by Hayden Duran?
This email has Hayden Duran's email in the front box.
Now, does this appear to be a fair and accurate copy of the email that Hayden Duran?
Yes.
Your Honor, at this time, plaintiff moves into evidence. State plaintiff exhibit 5.
No objections, Your Honor.
No objections, exhibit 5 is admitted into evidence.
Permission to show this to the jury.
May show it to the jury.
Now, without reading this entire email, what did you learn from it?
I learned that this email was sent from Hayden Duran to a coworker or friend, basically expressing his deep concerns about Jesse Duran only wanting to play with violent video games. It also recounts an incident in which Sidney Park and Jesse Duran were playing a violent video game, and Jesse Duran subverted the rules of the video game to no longer shoot the bad guys, but to shoot each other. Also concluded that...
Objection, speculation.
Where's the speculation?
In this email, it explains what Hayden Duran felt Jesse did, not actually the actions that Jesse took.
Response?
Your Honor, this witness had this email along with a variety about, as well as certain affidavits. There is no speculation on this witness's part. He did not say, I think this is what it meant. He's saying what is as a fact.
Reply?
Hayden Duran does not immediately know whether Jesse thought that that Jesse was subverting the rules, but merely just changing them. Or it appeared that Jesse was changing them.
I'm going to overrule the objection. Document speaks for itself. You may proceed.
What else did you learn about this email?
I learned that this email was sent out on July 1st, 2010, approximately 3 months after Hayden Duran received the referral from Jesse's school. In effect of that, Hayden Duran still failed to have his son evaluated by a child psychologist or anything of that nature regarding Jesse's behavior.
Permission to approach the witness and retrieve evidence. Dr. Solo, you told us the first risk factor was concerning his behavior, was the exposure to violent media, and the second being Jesse's behavior. What was the third risk factor that you saw in Jesse?
The third risk factor I found was presence of firearms.
Now, can you explain how Jesse was suffering from this risk?
Yes, it's a little less clear, but it's definitely there. Although Hayden Duran did not own a gun, Hayden Duran had knowledge that the Parks owned a gun. Also, Hayden Duran had knowledge that Jesse Duran knew of the Parks owning a gun and wanted an express interest in playing with the
Objection,
gun.
speculation.
Where's the speculation, counsel?
He does not immediately know whether or not Jesse knew there was a gun.
Counsel, I'm going to overrule the objection at this time. I'll let you develop this question a little bit further to clarify the issue of how he knew there was a gun. If you don't do so, the objection may be raised again, and I'll rule again at that point.
Yes, Sharon. You were explaining how Jesse was suffering from a risk with the presence of firearms.
Well, yes, like I said, although he didn't own a gun or have a gun in his home, the Parks owned a gun, and Hayden Duran had knowledge of that. He also had knowledge that Jesse Duran knew the Parks owned a gun, and that Jesse Duran expressed his interest to Hayden Duran about playing with the Parks gun. To me, that goes to my claim of presence of firearms.
Now, you said that your conclusion was based off these three different risk factors. Were you able to come to a conclusion with a reasonable degree of scientific certainty?
Yes. After reviewing all the materials and through my investigation, I concluded that Hayden Duran have known or should have known of Jesse's behavior. Jesse's Duran's
Objection,
behavior.
improper opinion.
How is it improper, counsel?
He is here to testify his two questions, whether Jesse exhibited signs of an obsession with guns and whether or not these were apparent before the date of the shooting. He is not here to testify whether or not Hayden Duran explicitly knew about these signs.
Response, counsel?
Your Honor, pursuant to Rule 704, an opinion of any witness is not automatically objectionable just because it embraces the ultimate issue. And the ultimate issue in today's case is whether or not Hayden Duran was a proper parent for Jesse. And because this witness's opinion ties in with that ultimate opinion in today's case, that ultimate issue, it's not inadmissible.
I'm going to overrule the objection. I'm going to allow the witness to testify not only the facts that he learned, but the conclusions he recently came to as an expert in that regard. You may proceed, counsel.
Dr. Sully, you're giving us your conclusion about what Hayden Duran should have known. Can you continue that conclusion for members of the jury?
Yes, well, according to the warning signs and risk factors I listed earlier today, they were clearly presented, and Hayden Duran should have known about these warning signs in Jesse Duran. He failed to have Jesse Duran evaluated by a child psychologist after the referral sent from Jesse Durant's school, him expressing his concerns about Jesse 3 months later, and all of this happened 5 months before the event that took place on August 18, 2010, which gave Hayden Durant more than enough time.
Thank you for your time, Dr. Solo. At this time, no further questions, Your Honor.
Thank you. Mr. Grillo, cross-examination?
Yes, Your Honor.